This is the Hoff Time Report with Idaho Freedom Foundation President Wayne Hoffman, one of Idaho's most respected, influential public policy voices.
Hey, welcome back. It's not surprising that the Idaho Supreme Court ruled against a new law requiring a more uniform collection of petition signatures in order to get an initiative on the ballot. Not surprising to me, anyway. What is shocking is how badly the court twisted itself into little bitty knots to justify its decision, much to the satisfaction of the state's leftists. Contrary to what the court said, the true story of the state's constitutional amendment allowing for direct democracy starts in 1911. This is when the legislature took up in earnest the progressive era's goal to let people propose and pass laws at the ballot box, bypassing the legislature. But lawmakers kind of got stuck on some key details, like how many signatures should be required to put a question before voters, and what threshold should be required for passage. Lawmakers even talked about an 80% threshold for passage. So lacking a resolution, but still wanting to move forward with an amendment for voters to ratify in 1912, the compromise was that the House and Senate would forward to voters a constitutional amendment that said the legislature at some point in the future would get to decide under the conditions and manner that initiatives make the ballot. Additionally, the amendment read that no initiative could pass unless approved by a majority of electors casting their ballots for governor. Now, the Direct Legislation League, which was the principal advocate for the initiative process being added to the Constitution, they were horrified that these two details were accepted, but decided to go forward with it as being half a loaf better than no loaf. Indeed, the lead member of the Direct Legislation League was a state senator, and he supported the initiative as it was contemplated by the legislature. Later, however, the League officially reversed its position and opted to oppose the initiative amendment. But that initiative amendment passed anyway and remained in its present form until 1980, when voters removed the connection to the results of the gubernatorial election. The point being that the legislature never intended to create what the state Supreme Court now labels a fundamental right. In truth, the initiative was always supposed to be a process that was well restricted under terms and conditions set by the legislature with a somewhat high bar for passage. The court, though, decided to ignore all of this, building its arguments around a 1915 bill that the governor at the time, Moses Alexander, vetoed, citing constitutional concerns. There is no real basis for denying the legislature's constitutional prerogative to oversee the initiative process, but it's obvious that the court is now an activist bench, substituting its judgment for that of the state's elected representatives and senators. The court decided that the legislature's explanation for wanting signatures gathered across the state, including in rural counties, is just not good enough. Why? Because the court said it's not. And as is usual for legal proceedings, the court need not be right. It only need to have the last word. So Idaho's top jurists now view the initiative as a vehicle to act, in their words, in a democratic fashion to protect the minority interests when the Idaho legislature would not. As the justices unanimously ruled, they declared the legislature's efforts to try to limit the initiative as being tyranny of the minority. Again, their words. Of course, this turns our constitutional republic on its head, wherein safeguards exist to prevent the majority from riding roughshod over the minority via mob rule. This is the kind of crappy result you get when no one is asking about the political and ideological leanings of the members of the court. This summer, when Governor Little appointed government lawyer Colleen Zahn to the Idaho Supreme Court to fill a vacancy, I asked the office what he had done to ensure a conservative was being added to the bench. 2 emails, no response. And that speaks for itself. Equally bad, in judicial elections, candidates show up for Republican events, virtue signaling, with their attendants that they might be conservatives while refusing to answer any questions about their stances on anything. This is the formula that has been used to move the judicial branch to the left over the last 2 decades, allowing the likes of Jim Jones to rise to the rank of Chief Justice. Idahoans deserve to know if their laws are being evaluated by people aligned with Ruth Bader Ginsburg or with Scalia. Without the right questions being asked, or with judicial candidates refusing to answer, the court is now firmly planted left of center, validating the concept of mob rule and cutting in its wake legal precedents that are dangerous to our state's future. Thanks again for watching. Be sure to hit the like button, subscribe, drop a comment down below, and we'll talk to you again next time.
You've been listening to the Hoff Time Report with Wayne Hoffman. Be sure to visit idahofreedom.org for Wayne's articles, IFF research, and show notes from today's episode.